Investors in Ripple XRP were keenly observing the close of the fact discovery phase that was supposed to happen on August 31st. The recent turn of events in the lawsuit, however, says otherwise. What are the new developments in the lawsuit? What does it mean for XRP? Stay tuned till the end and find out how to proliferate your money.
The good news is you're about to make a lot of money.
Subscribe to our channel and make sure to enable all your notifications to keep up with all the hottest secrets in the world of XRP. Done? Alright then, let's get straight into the topic. The Securities and Exchange Commission, Ripple Labs, and the individual defendants recently filed a joint motion requesting an extension for the deadline of the fact discovery period. This is a frustrating turn of events for all XRP holders and exchange platforms along with fintech firms, partners, and clients who want to see the lawsuit end as soon as possible. The motion asks the court to permit the SEC to conduct depositions of the chief executives of Ripple, Brad Garlinghouse and Chris Larsen, after the August 31st fact discovery deadline. The motion states that the unexpected illness of an attorney for one of the parties who was integral to the Larsen deposition and the intervening vacation schedules of other attorneys, the parties will not be able to reasonably complete the previously scheduled depositions of Garlinghouse and Larsen before August 31. Along with this, there are the intervening vacations of other attorneys. Ripple and the SEC requested the court to conduct the depositions of Garlinghouse and Larsen on September 14 and September 20. This is the first request made by either side to conduct depositions after the deadline of fact discovery. If the court does not allow the dismissal of the pending motions of Garlinghouse and Larsen, the discovery between the SEC and the individual defendants will have to continue for another 120 days.
It will take a long time.
On June 14, Magistrate Judge Sarah Netburn gave a nod to the SEC's request to extend the deadlines to investigate Ripple's documents by 60 days. Ripple had opposed the SEC's request and had called this delay an existential threat to its market in the United States. On August 31, the SEC was bound to wind up their fact discovery on Ripple. On October 15, the SEC's deadline to conduct expert discovery would have to come to a close.
Robert, you have a deadline?
This lawsuit agenda was updated on 27 August, thus dragging the case on for longer. The expert discovery date would be moved from October 15, 2021 to November 12, 2021. Any kind of settlement would happen only after the fact discovery is done. But it is likely that this would only take place after the expert discovery deadline on November 12. Attorney James K. Fallon, after observing the current trends in the case, commented, "In my experience, anyone who thinks this case is settling anytime soon should reconsider." In addition to the deadline extension request, the SEC versus Ripple lawsuit has a new update to its agenda. A telephone conference is scheduled for August 31 to discuss the pending privilege dispute.
Let's discuss this like gentlemen, yeah?
Earlier this month, attorneys James K. Fallon and Jeremy Hogan had discussed the likelihood of a settlement occurring earlier than expected. Attorney Jeremy Hogan had been carefully monitoring the case and providing regular updates on the lawsuit in his YouTube channel Legal Briefs. He says that the lawsuit is favorable for Ripple in any scenario, as the win in the end would definitely be for Ripple. He had discussed that the settlement between the two entities was likely to take place after the discovery phase. Discovery phase is a pre-trial phase where both the parties, SEC and Ripple Labs, will present before the court relevant information they gathered against each other. This phase exists in case the parties could reach a settlement before the judiciary gets involved. Recently, the SEC filed a motion in which their attorneys stated that there is no realistic prospect that the parties will fully resolve this case for several months, if not longer. The most recent events in the XRP lawsuit include Ripple attacking the SEC's contradictions using William HINMAN's deposition. It was ordered by Magistrate Judge Netburn after overruling the SEC. HINMAN's deposition was a crucial event because he had given a speech in June 2018 which gathered a lot of criticism. This speech still appears on the SEC website, and in it, HINMAN declares that Ethereum's digital token Ether is not a security despite having been launched in an initial coin offering in 2014. In April of 2020, the SEC had published the Framework for Investment Contract Analysis of Digital Assets. This publication draws a whole lot of its parameters from HINMAN's infamous 2018 speech. Hinman said in the speech that based on his understanding of the Ethereum network and its decentralized structure, the current offers and sales of Ether are not securities transactions.
No, it is not.
The SEC denied their responsibility for the speech. They claimed that the speech solely reflected Hinman's personal views and was not market guidance. The existence of this publication is clear evidence that the SEC had been lying when they claimed that the speech was not market guidance, but merely Hinman's personal take on digital assets transactions. This meant a significant stride forward for Ripple in the lawsuit.
Awesome.
The SEC had put forward an argument back in July that Hinman's deposition would create a precedent by deterring other lawyers from joining public servant jobs. Judge Netburn retaliated that this is not a run-of-the-mill SEC enforcement case. She observed that Hinman's deposition will open the floodgates for all government officials who have spoken about securities or crypto. She also acknowledged the importance of the case by saying that the case involves significant policy decisions in our markets. The amount of controversy is substantial, and the public's interest in this case is significant.
Now, this is important.
The stiff resistance from the SEC to this testimony has aroused suspicions in those closely following the lawsuit that the agency has something to hide and was trying its best to prevent the deposition from going forward. The fair notice defense that Ripple requested is going to be granted. This would mean that the SEC will be put on trial in what could be the cryptocurrency trial of the century. What the SEC's legal team feared was that Hinman's answers to Ripple's questions could put an end to their case and to their credibility as an agency. It would bring forth a ruling that could bring the SEC's lie of fair notice to an end. Ripple has also raised a basic question of due process. The SEC says it has the right to impose billions of dollars in fines over sales that began 7 years before the lawsuit was even filed. Ripple has been trying to figure out why the SEC is not targeting Bitcoin and Ether as well. Like XRP, BTC and ETH are decentralized currencies. Ripple has not conducted an initial coin offering upon launch. Ripple's claims in the court records show that it has never held an ICO, never offered future tokens to raise money, and has no contracts with the vast majority of XRP holders. Another concerning factor in this lawsuit is how the SEC put Brad Garlinghouse as a defendant. Garlinghouse hadn't even joined Ripple up until 2015, and he has been accused in this case during a time period in which he wasn't even part of the company. And in those 7 years, the SEC never provided any clarity over XRP. SEC officials made many speeches and appeared in many interviews in which they were very clear on the classification of Bitcoin and Ether, but they were surprisingly vague on XRP.
Pretty vague.
Earlier this week, SEC executive Gary Gensler took to Twitter to engage with the crypto community on the matter of regulations. He tweeted, "The spirit of the law is about protecting investors. Our rigorous enforcement regime is about following the facts and the law, wherever that may lead, on behalf of investors and working families." To this tweet, billionaire entrepreneur Mark Cuban, who is a crypto enthusiast and investor, retorted, "How about making the lines bright and clear so people know what the rules are? The problem isn't that people are looking for gray areas, it's that there rarely are defined rules. Regulation through litigation traps all the people who can't afford a lawyer, accountant, or advisor." The issue we have to be wary about here is that the SEC is left unregulated by the government regarding cryptocurrency. Until the government charts out a solid framework for cryptocurrency to operate, financial regulatory bodies like the SEC would continue perpetrating this overreach of authority. The Digital Asset Market Structure and Investor Protection Act, which was introduced in the Congress in late July, would be an answer to this problem.
What's your answer?
This act would regulate the digital asset market and protect crypto investors. Under this bill, XRP wouldn't be subject to the SEC's scrutiny. The XRP price as of August 27, at the time of making this video, is $1.13. The past 24 hours witnessed high volatility in the market. The global crypto market cap was below the $2 trillion mark and had fallen by 3% compared to the previous day. Even in this scenario, XRP had gone up by 1.67% in these 24 hours. And with that, we have come to the end of the video. Tell us your thoughts on what the lagging of the SEC lawsuit would entail for Ripple in the comments section. Do you think the real issues of the SEC's filing of the lawsuit against Ripple have been addressed? Don't forget to give this video a thumbs up. subscribe to the channel, and stay updated about everything XRP. Turn on the post notifications to be notified about new video uploads. See you all next time!